This is a video essay by Kyle Smith Doolittle on the depiction of Theodore Robert Bundy in the film Extremely Evil, Shockingly Wicked and Vile. This film follows the story of Ted Bundy, an intuitive and charismatic sociopath who kidnapped, raped, and murdered over 30 young women and children across the United States in the 1970s. I chose this movie because it has an eerie proximity to all of us. Ted Bundy was an alma mater of University of Washington and used to roam the streets around us. The craziness of serial killers is something that attracts our morbid curiosity. But in the many jurisdictions of the United States court system, would Ted Bundy be able to successfully plead not guilty by reason of insanity? Through this video, we'll examine 5 insanity defense rules and determine whether Bundy could have successfully pleaded insanity in the United States criminal justice system. In England in the mid-19th century, there was an assassination attempt on the Prime Minister of the Tory party that resulted in the accidental murder of Edward Drummond. The murderer was captured and identified as Daniel Macnaghten, a Scottish woodturner in his 20s, whose obvious paranoid delusions created an ethical conundrum in the English courts that reverberates to the present. The jury judged Macnaghten not guilty by reason of insanity, shaking the foundations of a justice system based on free will. The public was outraged, just as they were 30 centuries later with John Hinckley, but the House of Lords stood by and established this formal rule. In order to successfully use the Macnaghten rule, the defense must prove that the defendant was unable to understand that their actions were criminal, or that what they were doing was wrong due to a disease of the mind. Ted Bundy was an unusually organized, meticulous, and calculating criminal who used his extensive knowledge of law enforcement techniques to avoid capture for years. He committed murders across broad expanses of the continental United States, was unusually skilled in minimizing physical evidence, and would often change his appearance to avoid identification. Ted Bundy would likely be unsuccessful in using the Macnaghten rule because his actions to avoid detection from law enforcement proved that he knew what he was doing was wrong and against the law. The irresistible impulse rule expanded the insanity defense to include acts of passion, crimes where the defendant knew that they were engaging in wrong behavior, but were overwhelmed by an impulse they couldn't resist. This rule really broadened the insanity defense, removing the need to prove that the defendant knew the acts were right or wrong. The rule was first implemented in Ohio in 1934, but gained notoriety in the Twinkie defense of 1978. Dan White's lawyers were successful in reducing his sentence by arguing that severe stress and consumption of junk food diminished his capacity to resist his urge to murder Harvey Milk and George Moscone. Experts speculate that Bundy's murders actually spanned decades, as early as age 14 when he lived in Tacoma. Over time, his murder technique evolved in organization and sophistication, from forced late-night entries to elaborate ruses to lure his victims to his car. Bundy kept a duffel bag full of murder tools in his car and created fake plaster casts to feign disability. I don't believe Ted Bundy would be successful in using the irresistible impulse rule for an insanity defense. Bundy's murders were far from acts of passion in the heat of the moment. His crimes were meticulously planned and occurred with regularity over a large geographic area and a large span of time. The serial killer's irresistible drive to kill better fits the Durham rule. Established in 1954 by Judge David Bazelon, the Durham rule radically broadened the insanity defense by arguing that mental disorders are responsible for criminal behavior, not the person suffering from the disorder. To me, this is the most enlightened rule ever to grace the United States justice system, and there's evidence that as a society we are capable of reforming our thinking this way. An example of this is if a driver is unaware that they have epilepsy and has a seizure on the road that causes an accident. We don't blame or punish them for what happened. As a society, we recognize that the condition of epilepsy caused this unfortunate event to happen, not the person who had the seizure. We don't burn them for being a witch or preach to them about immorality. We just take away that person's driver license to prevent further accidents. Our criminal justice system could be reformed in a similar way. In order to successfully use the Durham rule in an insanity defense, the defendant must be diagnosed with a legitimate mental disorder by a mental health professional. It does not require the defendants to prove that they were incapacitated by the disorder or that they understood their actions were illegal or wrong. Many mental health experts have concluded that Ted Bundy met the diagnostic criteria for antisocial personality disorder. Under the Durham rule, Ted Bundy would likely be successful in arguing the insanity defense because his mental disorder made it impossible for him to suppress his impulses, regulate his emotions and behavior. In 1962, a group of lawyers, judges, and academics associated with the American Law Institute tried to redefine the legal definition of insanity, which resulted in the ALI rule. In order to successfully use the ALI rule, it must be proven that the defendant cannot appreciate the immorality of their crime due to cognitive or emotional symptoms resulting from a psychological disorder. The biographer Anne Rule, a friend and co-worker of Bundy's, wrote that Ted Bundy was a sadistic sociopath who took pleasure from another human's pain and the control he had over his victims to the point of death and even after. In 1981, Bundy said, "Guilt doesn't solve anything, really. It hurts you. I guess I am in the enviable position of not having to deal with guilt." Though Ted Bundy did not have the emotional capacity to appreciate the horrors of his crimes, he still maintained the ability to distinguish right from wrong. It just had minimal effect on his behavior. He would likely be unsuccessful in using the ALI rule for an insanity defense, since he was able to differentiate right from wrong, and his abnormality manifested only by repeated criminal conduct, considering he was a somewhat successful university student and family man. Following the trial of John Hinckley, Congress enacted the Insanity Defense Reform Act, which again reformulated the definition of insanity. In order to successfully use the Insanity Defense Reform Act, the defense, rather than the prosecution, must prove that the defendant was insane at the time of the crime. Ted Bundy maintained his innocence even when faced with undeniable evidence at his final trial in Florida. After he dismissed his public defenders, as a former law student, he achieved some minor successes in mounting a defense for himself. Combing through the law books in prison, it must have occurred to Bundy he could have pleaded insane, but he chose not to because he felt no remorse for his crimes. It is unlikely Ted Bundy would have been successful in using the Insanity Defense Reform Act to plead guilty, as he would not admit to himself that he was insane committing these crimes.